Hello, and welcome to my presentation. I will give you a brief introduction to what this presentation entails. In essence, this will look at the concept of registered and unregistered land and how the modern land law can work towards better methods of implementing reforms with the aim to improve the Land Registration Act of 2002. Additionally, I will also go into an analysis of potential drawbacks pertaining to the Land Registration Act of 2002. Now, when looking at the LRA 2002, there are mainly three principles that entail and depict how land is treated: the mirror principle, the curtain principle, and the insurance principle. I will go into a further depth of how these three principles interact and how the mirror principle has its certain drawbacks. Now, before I go into that, I would like to give a brief summary of what land registration is and the different types of land regimes. So there are primarily two types of land regimes, which are registered and unregistered land. Now, normally registration of land occurs after conveyancing, and registered land holds different types of interests to which parties can be found in the land. It was also noticed in the case of Scott v. Southern Pacific Mortgages by Lady Hale that land registration system is simply a tool used for conveyancing, and that the underlying legal principles in relation to interests and states remains the same. It replaces the evidence that in regard to the entitlement of land, which was previously provided via a title deed, more so registration also prevents the involvement of third-party rights affecting the land, such that any type of purchaser is fully aware of any other rights pertaining to such land. This can be seen under Section 29 of the LRA, where there's a clarification that any type of purchaser that comes across the register is solely bound by only rights which are registered upon the electronic register. And this also goes on to say that there will be some sort of overriding interests that will also be discussed later on within this presentation. Now, having mentioned that, I will look at how the mirror principle works in conjunction with the two other principles. Now, to start with, the mirror principle implies that the land register needs to be perfect like a mirror. It must state that all individuals who own land, all rights or limitations that are applicable. The concept is such that all people can base their reliability on the register without the necessity to turn their back and see what happened before in old records. This makes the transfer of property to be done much faster. The main objective here is that registration of a system, which should be an accurate representation and reflection of a land title, such that upon any sort of investigation, there is minimum additional requirement that is needed. Just like a mirror, the register must accurately reflect the position of land ownership and and with extension to that, any third-party rights binding to it. Seemingly, the title was not taken for registration. Now, the LRA promotes this principle under Section 28. In summary, this states that in the event of any gifted land, the transferee should also be bound by all pre-existing rights that they have not been registered. Now, Section 58 also makes it clear that the entry of rights on the register is conclusive, preventing any sort of new information that shall be added. Now, Section 27 helps to understand that any changes to ownership within land must be updated within a time period of 2 months, and thus legal ownership does not pass on until the purchaser applies for this registration. Now, to support the mirror principle, we have the curtain principle. This principle implies that some of the private interests, especially trust rights, remain behind a curtain. This can be seen under Section 2 of the LPA of 1925. This entails that purchasers need not go behind complicated family trust structures, and that they have to trust the register and to deal with the legal owner upon the register. The principle works hand in hand with the mirror principle in order to provide smooth methods of land registration, thus making it clear to any sorts of purchasers in the event of equitable rights pertaining to land. Now, in order to understand this, we must understand what sort of equitable rights pertain to land. There are mainly two types of equitable rights. These are within family, or companies. Now, the curtain principle mainly revolves around another mechanism which is known as overreaching. In simple terms, overreaching allows the buyer of land on conveyance of legal estate to take a title of land under a trust or a settlement which he has no notice of. It allows equitable interests, which are thus not mentioned within the register, to be transferred from land into purchase money. The purchaser may pay forward the land money to at least two of the trustees. In the case of Flegg and Birmingham Mid-Shares Mortgages Services, it presents how the concept of overreaching can also bypass actual occupation in land and thus supports the curtain principle. In this case, despite Mrs. Flegg having lived up on the land, the building society rights took legal charge. The building society's rights under the legal charge took precedence under the mortgage. It is also important to understand the relationship between the two concepts of overreaching and overriding of land, such that if land interests cannot be overreached, such that they are no beneficial equitable interests under a trust, it nevertheless may still be subject to an overriding interest which relates to the mirror principle. And I will go further into detail of what an overriding interest is. However, it is important to know that if an interest cannot be overreached, it still may also be overridden. Now, there are certain conditions for overreaching, and this can be seen in the case of Kings North France versus Tizard. It sets out that in the case that there is only one beneficiary, overreaching cannot occur. Overreaching must also occur in the case of where there is any sort of trust structure within the land. Now, in the case of HSBC versus Dyke, this case revolves around how the curtain principle also prevents fraud, as Mrs. Dyche fraudulently mortgaged the property to HSBC, forging documents and acting without the knowledge or consent of the beneficiary. Thus, a curtain principle also protects the true beneficiary from fraud. Now, lastly, we'll look at the insurance principle and what it is. This principle basically allows parties to have the right to be compensated in the event that the register is proven to be as a result of error or fraud. It gathers the confidence of people within the system. So, in total, the three principles make it sure that the land system remains open, vividly clear, and easy to use. Now, how must the insurance principle relate to the mirror principle? The interrelation is such that the mirror principle reflects the true knowledge of what is held within the title, and thus it is held that in any event of fraud, this must accurately be mirrored and reflected such that any sort of loss pertained by the purchaser or by human error or mistakes, it must be compensated in terms of monetary values. And this will happen such that the state will, via the land register, provide the parties who have suffered any sort of loss insurance covering individuals who undergo flawed land transactions. However, having now given an overview of how the mirror principle operates, it is important to understand that it does not always give the reality check that it is prided for. Next, I would like to evaluate how well the mirror principle works, and as well as what are their drawbacks in real life. The main concept is that the register serves as a whole and sound representation of the title. However, in practice, there are very obvious cracks in the mirror. This can be seen in the case of Cestile Limited v. Alton House, where the phrase cracks were actually seen. Now, there stands about 10% of land that has not yet been registered, and in such case of properties, there is no mirror that exists, and thus buyers must examine paper deeds, which is more time-consuming and expensive and adds the opportunities of undisclosed issues such as fraud. Now, second, in order to understand the concept of overriding interests as mentioned in the slide before, it is integral to explore what type of interests exist under the LRA. Now, interests that override, which are outlined under Schedules 1 and 2 of the LRA, and such examples of these interests include occupant rights of individuals actually living on the land, short-term leases not extending 7 years, and some types of legal easements or rights of way. These interests thus bind buyers not even if it is not reflected within the register. Now, if there is an actual occupation in the land at the time of sale, the case of Hudson v. Marks sets legal precedent that continued physical presence on land is enough to qualify as actual occupation. It is also outlined within paragraph 2 of the LRA, like this concept is also represented within here. Their occupation is easily found reasonable on an inspection of land where there is active knowledge on behalf of the purchaser on such interests. However, if the person is occupying the land did not disclose that information concerning that they had reasonable opportunity to do so, then no such interest will be binding upon the purchaser. This is shown in the case of William Glynn's Bank, where it shows that anyone that is in the position of not being privy to a fact, such as spouses living on the land, shall be protected by law. Though this can be a crack in the mirror, this shows how the LRA still upholds equality in terms of protecting other occupants too. Now, secondly, when looking at what amounts to short leases, it must be a time period of 7 years or less. The lease, however, must be a legal lease too, and that is seen under Section 52 of the LPA 1925. However, the LRA seeks to encourage the registration of leases which are over 3 years but less than 7 years in order to prevent confusions on overriding interests. Now, paragraph 3, schedule 3 of the LRA represents that legal easements which are created via a deed or by implication can act as overriding interests. The three main aspects allow easements to qualify as an overriding interest. The first is that if it is known to the buyer, it can be said to be obvious on reasonable inspection of the property, and finally has been used within the past year. The main purpose is to protect unregistered rights of way. An example can be rights to using a shared driveway. Now, the same case of Sasteel Limited, it was recognized by the Court of Appeal that there are some legal easements which do in fact override the terms of a register, such that even if the buyer was not privy to the interests binding to the land, thus limiting the purpose of the mirror principle and providing its limitations as the buyer is not fully aware on the legal rights. Overriding interests override the land title and the new purchaser. It requires no registration, and thus the doctrine of notice, which requires the buyers to have relevant notice on the rights pertaining to the land, is thus irrelevant. Now, third, the accuracy of the mirror is also broken down by human errors and fraud, and thus such bogus transfers cannot be ruled out. Fraudsters can impersonate actual owners and sell out the land in an unofficial manner. Though the insurance principle applies that the state should compensate it, it does not make it possible to eliminate tension, expenses, or disputes. Thus, in most of our daily transactions, this mirror principle actually holds good, but there are, as seen above, cracks in the mirror that prove that it is not a perfect means of practice at all. Hence, in this practice, it depicts that the mirror principle is beneficial, but it is not free from flaws. Now, I would like to go on to showing some sort of reforms that can be implemented. Now, in the end, what would be the purposeful reforms which can help improve the LRA 2002? Now, over here, there are 4 possible reforms which I have come up and I have explored, which can eventually help to fix the issues as previously mentioned. Now, the first will be comprehensive registration, with setting up clear deadlines and linking registration to property sales. Incentives can be offered for those registering their land voluntarily. Second, the decrease in the scope of overriding interests, now encouraging more rights to be recorded directly upon the register, hence making hidden surprises less likely for buyers. Now, third, improving fraud prevention with the help of stronger checks for identity updated and improved digital systems and fast-paced error rectification. And fourth, finally, public awareness campaigns that are freely available to plenty buyers and owners, educating them on their rights and duties under the registration system. More so, there should also be an open and clear guidance that will reduce mistakes and disputes. These reforms will help create fully trusted, accessible, and modern register for everyone within England and Wales. I would like to thank you for staying through and attending my presentation. And the final slide will show the reference list as well as any cases that have been referred to within this presentation. All the references and cases are following OSCULA referencing format. Thank you.